Mga tao, lugar at organisasyon na may kaugnayan sa kaso na tampok sa palabas na ito ay pinalitan at binago. Ang anumang pagkakahawig ng mga bagong pangalan sa aktwal na tao, lugar o organisasyon ay hindi sinasadya at nagkataon lamang.
The rights of the accused include the right to a fair trial, due process, the right to seek redress or a legal remedy, and the rights of participation in civil society and politics, such as freedom of association, the right to assemble, the right to petition, the right of self-defense, and the right to vote. Currently, in many countries with a democratic system and rule of law, criminal procedure puts the burden of proof on the prosecution. That is, it is up to the prosecution to prove that the defendant is guilty beyond any reasonable doubt, as opposed to having the defendant prove that he or she is innocent. Any doubt is resolved in favor of the defendant. Similarly, all such jurisdictions allow the defendant the right to legal counsel and provide any defendant who cannot afford their own lawyer with a lawyer paid for at the public expense, which in some countries called a court-appointed lawyer. This episode will delve into the rights of the accused as stated in Article 3 of the Constitution. What if a seller imposed a price on his goods contrary to the maximum 20 centavos fixed by an executive order in accordance with Section 19 of Article 3 of the Constitution? Is it proper that he be charged with a pecuniary fine and a 5-year imprisonment for his act? In the morning of October 14, 1950, Juan Dera Jr. went to Pedro de la Cruz's store in Sampaloc, Manila.
Juan! Gising na! Hoy! Juan! Gising na!
Ito na! Ano? Pabili! Meron ba kayong carnation dyan?
Wala na kaming carnation. Ubus na stock namin.
Saan ako makakita nito? Bossing! May carnation ba kayo dyan? Yung carnation milk ba?
Carnation?
Oo.
Teka lang ha, hanapin ko muna. Eto, meron na. Oo.
Magkano to, bossing?
30 centimos lang.
30 centimos?
Oo, kaya mo
Mira,
na
wala
yan.
na bang tawad dyan?
Wala, naghahanap buhay lang, boss eh. Kaya mo na yan eh.
O ito. Salamat ha.
Salamat.
Pare, pambihira naman oh. Kung kailan mo pa talaga ako inutusan, doon pa talaga sa kaaway mo.
Ano? Ano ba pinagsasabi mo? Ang aga-aga pa, nagkaaway ka na?
Naglibot ko na lahat ng stalls. Doon pa talaga ako makakabili sa pinakamatalik mong kaibigan. At ang mas malala pa dyan, i-overprice yung presyo. Akalain mo, 30 centimos? Eh, binili ko na lang. No choice naman ako eh. Kesa naman na wala akong madala dito, di ba?
Ano? Ito? 30 centimos? E 20 lang ito sa iba. Yang De La Cruz talaga na yan. Kung ako talaga magkakatindahan, hindi ko yan patatawarin. Kahit wala man akong benta, isusumbo ko talaga yung gagawin yan ng matuto.
Fueled by Cardo and Pedro's long-standing feud with each other, Cardo decided to complain Pedro's overpriced carnation to the city's fiscal office, which resulted in this criminal prosecution. Because Executive Order No. 331, issued by Authority of Republic Act No. 509, fixed 20 centavos as the maximum price for that kind of commodity. The Supreme Court sentenced Pedro de la Cruz to imprisonment for 5 years and to pay a fine of 5,000 pesos plus costs. He was also barred from engaging in wholesale and retail business for 5 years. The damage caused to the state is not measured exclusively by the gains obtained by the accused, inasmuch as one violation would mean others, and the consequential breakdown of the beneficial system of price controls. In overstepping the price barriers, he might derive profits amounting to thousands of pesos. Thus, the penalties imposed were within the statutory limits. Convicted De La Cruz, while serving sentence, unfortunately became mentally ill, which when assessed by a psychiatrist was diagnosed to be suffering from severe mental illness. His counsel appealed for the suspension of sentence trial.
Defense appeal is hereby granted. So ordered.
Supposing that in an act of paying a debtor issued a worthless check that resulted into a criminal action before the court against him, can he invoke the defense embodied under Section 20 of Article 3 of the Constitution?
Dok, kung inyo po kasing makikita, parang nahihirapan po kasi yung simbahan imusad ngayon dahil sa konting maninimba nito. Kung pwede lang po sana, Dok, pwede po kami pumutang sa inyo?
Oo naman, Father.
Amin po kasi nakwenta or nabilang po namin 250,000 po yung kailangan namin sa simbahan na to. Meron ba kayo nito?
Oo, wait lang ha.
Salamat po, Dok.
Kung ito, Father, sakto-sakto, 250,000.
Talaga, Dok? Ako, sobrang maraming salamat po sa inyo. Bukas, napapatupad na po namin ang plano namin sa simbahan. Pangako, Dok, babayaran po talaga namin kayo bago mag-October 4.
Oo naman, Father. Maganda yan, pero tanong ko lang, paano pag hindi kayo nakabayad?
Naku, Dok, huwag na po kayo magduda. Sigurado po talaga na babayaran po namin kayo. If ever man na hindi namin mabayaran, isasangla po namin ang ari-arian ng mga simbahan para sa pangalan niyo. Maraming salamat talaga.
Oo, sige. Maniniwalaan ko yun, Father.
Thank you, Dok. Thank you talaga.
Sige, Father.
Hala! Due date ko na pala sa utang mo kay Dr. Espanya. Pero wala pa rin akong pambayad. Ano kayong gagawin ko? Alam ko na!
Uy, Father! Uy, Father!
Ops. Ito na po ang utang ko sa inyo, Dr. Espanya. 250,000, walang labis, walang kulang. Cheque sa pangalan nyo. Notice of complaint? Ba't niya ako kakasuhan? Nakabayad naman ako ng utang ko Hindi pwede ato. Hindi ako pwede makukulong.
No, because the act employed by Father Clint is categorized as criminal in nature. Under Section 20, Article 3 of the Constitution, no person shall be imprisoned for debt or non-payment of a poll tax. Accordingly, as long as the debt arises from a contractual obligation, not for fines imposed by the state, not for commission of crime, or civil liability from the commission of a crime, you cannot be imprisoned. In the case at bar, the defense under Section 20, Article 3 of the Constitution is unmeritorious because the act that is being punished under Batas Pambansang bilang 22 is the issuance of a worthless check or a check that is dishonored upon its presentation for payment, which is an offense against public order and criminal in nature. Thus, subjects Father Clint to conviction.
Defense contention is hereby granted. So ordered.
What if a person was previously convicted with reckless imprudence resulting in slight physical injuries? Does it follow that he cannot be further charged with reckless imprudence resulting to homicide and damage to property that arose from the same crime?
I'm sorry, boy. Pero I don't know if I still love you.
Ganun na lang ito, Bash. 5 years. Itatapon mo lang lahat yun?
I'm sorry, boy.
Seryoso, babe? Ikaw, Mark, malaki na yung katawan mo pero di mo ko kaya
Boy,
patumbahin.
tama na, boy!
Manda kayong dalawa. Makikita nyo rin.
Mark! Mark!
nga yung pulang kotse.
Copy, sir.
Ano to?
Wala ako dyan. Hindi ko na alam
Nakita
yan
mo ba
eh.
to?
Hindi ko alam siya ang nauna sa akin eh.
Wala nga dito.
Wala talaga ako dyan.
Nakikita mo ba yung
Hindi,
tinadaanan ko?
apat ako makuhuli. Wala ako dyan eh.
Wala. Sa bisita ko lang palawanan.
Isang retired military US officer na pamangkin ng isang patikang singer na si Kuya Eddie at anak din ng isang sikat na aktivista at manunulat. Nakabangga sa Cebu Business Park Avenue, isa patay.
On the afternoon of April 20, 2018, the accused Popoy Bartolome, riding a silver Honda car with the plate number ABC-123, collided with a red Volvo car with the plate number DEF-111 with the two passengers, namely Bea Basha Alonzo and Mark John Batumbakal, and resulted to the death of Mr. Batumbakal. The accused in the case of 123-456 is charged of reckless imprudence resulting to physical injuries against Bea Basha Alonzo and a crime of reckless imprudence resulting in homicide and damage to property against Mark Batumbakal. Accused, do you plead guilty or not guilty?
Not guilty.
Tuluyan na ngang nahatulan ng Korte Suprema ng reckless imprudence si Popoy Santa Rosa laban sa nabangga nitong si Mark Batumbakal na namatay matapos mabangga sa Cebu Business Park Avenue, Cebu City noong Abril 26 nitong taon. Kung matatandaan, si Popoy Santa Rosa ay isang retired US Navy at pamangkin ng isang sikat na mang-aawi. Maria Mercedes, nag-uulan.
Yes, the protection afforded by the Constitution shielding the petitioner from prosecutions, placing him in jeopardy of second punishment for the same offense, bars further proceedings in criminal case number 123456. The accused's negative constitutional right not to be twice put in jeopardy of punishment for the same offense protects him from, among others, post-conviction prosecution for the same offense, with the prior verdict rendered by a court of competent jurisdiction upon a valid information. The Supreme Court held that prosecutions under Article 365 should proceed from a single charge, regardless of the number or severity of the consequences. Therefore, reckless imprudence is a single crime. Its consequences on persons and property are material only to determine the penalty.
Defense appeal is hereby granted. So ordered.
Can a member of a Communist Party of the Philippines charged for his violation of RA 1700 assert that it cannot apply to him for such law is a bill of attainder, thus unlawful?
Kapatid, lumapit kayo. Narito tayo lahat para magpulong kung paano natin ilalapag ang ating pangalan sa kasaysayan ng Pilipinas. Ikaw kapatid, anong nasaga mong balita?
Sa pagtatanong ko sa bayan, pinuno, nalaman ko na ang presidente ay maghahayag ng kanyang talumpati. Sa makalawa, alas 8 ng umaga, pinuno, may kasama siyang sa napag-alaman ko mga 10 security. Ano po plano natin?
Parang mahirap yata yan ah. Ikaw kapatid, anong may bibigay mong solusyon para sa plano natin?
가지가 뭐가 나가 지금 머리끼 뭐가니까 같이 보러가 보고 저 베리크인 거죠 지금 무지개 가래가리가 뭐하는 거지가 티깔라 보고 티까 보고 차
Ang ibig niya pong sabihin, pinuno, maglalagay tayo dito ng 10 armadong tauhan bawat sulok dito sa lugar at saka maghihintay tayo ng kanyang hudyat bago tayo sasalakay. Ano ba, pinuno? Okay ba yun?
Sige, tuloy ang plano. Ano to?
Huwag ka na lumaban! Sumama ka sa presinto!
Good morning, Verdict Santos. I am your attorney for the case charge against you. Kailangan natin pag-usapan to.
Yes po, attorney. Pero may tanong ko sa batas na ipinapataw sa akin. Opo, may connection ako sa Communist Party of the Philippines. Pero hindi ba bawal yung batas na pinapataw sa akin? Yung pong tinatawag nila na Bill of Attainder?
Tama po kayo. Bawal po ang Bill of Attainder. However, sa kaso niyo po, hindi po natin matatawag na Bill of Attainder ang Republic Act 1700. A Bill of Attainder is a law or a bill that singles out individuals or a group that, would create punishment for certain individuals without punishment or trial. To make things clear to you, Mr. Berting, this applied only when a statute names certain individuals in order to easily ascertain members of a group in such a way to inflict punishment on them na walang judicial trial na nagaganap. Ang RA 1700 ay magiging Bill of Attainder lamang kung nakasulat sa batas ang mga pangalan mo at inyong mga kagrupo. But I must assure you, as long as hindi pa tapos ang kaso mo, you are still innocent.
Thank you, Father.
No, because RA 1700 did not make mention of the names of the members of the CPP nor names of the members of other organizations with the same goal of the CPP. A law may only be considered to be a Bill of Attainder if it singles out an individual or group for punishment without a trial.
Defendant is hereby convicted. So ordered.